Welcome to the new Labor and Workforce Continuing Education series. My name is Amy Patillo, and I am a Labor and Workforce Specialist located in Springfield, Missouri. This webinar series represents an outgrowth of past collaborations between MU Extension Labor and Workforce Development and the Department of Labor. In the past, the Department of Labor has graciously served as guest speakers for the Labor Law series hosted in St. Louis and Kansas City. It is an honor to welcome Kathy Robinson, JD, from the Department of Labor. Over the course of the next 2 months, we will offer a series of webinars that will prepare your business, agency, and organization for its legal obligations and responsibilities. And we will connect you to the resources and experts that can help you navigate these complex employment obligations. I would like to also announce the University of Missouri Extension Labor and Workforce Development has applied for continuing learning education units with the Missouri Bar Association and the Missouri Social Workers Organization. And we're pursuing other continuing education avenues. Once the topics have been approved, one will be able to purchase the CEs from the same registration portal that you use to register for the webinar. And for a final housekeeping note, I wanted to let you know that the presentation will be recorded, but we'll stop the recording for the question and answer session. Please post your questions in the chat feature or save your questions till the end of the presentation. It is my pleasure to introduce Ms. Kathy Robinson. Ms. Robinson has worked for the Department of Labor Employee Benefits Security Administration as a benefits advisor since 2007. Based on ERISA and related laws, she educates the public and fiduciaries regarding compliance assistance and educates the public and helps them resolve issues they experience regarding private employer or union-sponsored plans. Prior to working for the Department of Labor, she was a senior mediator for the City of Kansas City, Missouri, the director of mediation at the University of Missouri, Kansas City, the executive director of the Western Missouri Coalition to Abolish the Death Penalty, and was a legal aid attorney specializing in family law and mediation and teaching conflict resolution. Ms. Robinson has 2 Bachelor's of Arts degrees, one in psychology and one in sociology from the University of Missouri, Kansas City. She also matriculated from the University of Missouri, Kansas City School of Law with a Juris Doctorate and from Antioch University with a master's degree in conflict resolution. She's been an attorney since 1995 and a mediator since 1996. It is my honor and my pleasure to introduce Ms. Kathy Robinson.
Thank you, Amy. And as you know, I'm Kathy Robinson, and it's my pleasure to be with you today. And I hope you find the material on basic ERISA law for group health plans and retirement plans, and the information and resources about the agency that I work for, the Employee Benefits Security Administration with the U.S. Department of Labor, helpful for you today. Doing these outreach presentations is one of the more enjoyable aspects of my job, and I also appreciate the opportunity to get to do these presentations, and I'm enjoying working with Amy and Matt with the University of Missouri Extension Program. If you'd like me or someone from my office to come out and do a presentation on a topic related to ERISA that we're going to talk a little bit about today, we would be happy to do that. If you have another question that you'd like to ask me, you're welcome to do that as well. My contact information is 816-285-1874 is my phone number. My email address is robinson.kathyj@DOL as in departmentoflabor.gov. So ROBINSON.KATHYJ@DOL.gov. And so basically, I'm going to talk a little bit about what I do as a benefits advisor. One of the things that we do is these outreach presentations. So if you work for a nonprofit and might want to have us come out, like I said, feel free to contact me, and I'll be happy to try to set something up for you. But as we're into the presentation talking about the information and resources that EBSA offers, one of the resources available to you are the benefits advisors, such as myself. And we staff a toll-free line Monday through Friday from 8 to 4:15, where we answer questions from the public, fiduciaries, plan administrators, employers, plan sponsors, et cetera. We have 10 benefits advisors in the Kansas City office, and we cover 11 states. And I'm proud to say that generally we're able to answer the phone within just a few minutes, if not immediately. And the number for our toll-free line is 866-444-3272. One of the things that I like to talk about with regards to presentations is kind of the audience that I had in mind as I put the presentation together. And this, as you'll note in the title, is basic ERISA law for the various plans we have jurisdiction over, as well as what you can get from EBSA, what we have to offer you, the resources that we have available. But even though I use the word basic, I think there are things not only for people who don't have a background in ERISA or are new to group health plans and retirement plans, but also for more seasoned or experienced people as well. As part of the handouts, there is a resource list where it includes publications that we have, fact sheets, information about different programs that we offer with links to those that I hope you find helpful. And another aspect of this presentation, even though I focus on the most basic aspects, is that I talk about issues that are important to know that we take very seriously, and that it's also something that plan sponsors or administrators might not understand unless someone like me tells them about it in terms of how they look at certain parts of the law or how they comply with certain parts of the law. So that's something that I hope you'll find helpful today too. One thing that I want to mention also is that if you are attending more than one and perhaps several or all of the webinar series that we are offering, partnering with the University of Missouri Extension, you might notice that there's a little bit of overlap between presentations. For instance, today I'm going to talk about a little bit with regards to fiduciary duties that are inherent in group health plans and retirement plans under ERISA. Well, several of the programs that we're offering will focus on the fiduciary duties related to those specific programs. For instance, I did compliance assistance last week, so that included fiduciary duties regarding COBRA compliance assistance. In the future, there will be, I will be doing a program on group health plan administration and another one on retirement plan administration fiduciary duties. So those will have much more detailed and specific information with regards to focusing on the fiduciary duties for those plans. But we do touch on it a little bit in today's presentation. Today we'll talk a little bit about wellness programs and the Mental Health Parity Act, but we have future programs that are devoted to those topics entirely. On August 6th, we'll be doing a program on wellness programs. On August August 12th, we'll be doing wellness programs. On August 19th, we'll be doing a program with regards to tips and tools that you hopefully will find helpful with regards to compliance with group health plans and COBRA. And then on August 26th, we'll have a program focused entirely on the Mental Health Parity and Addiction Equity Act. But we'll touch on that a little bit in today's program. So I'm hoping that you'll find this helpful. Let's go ahead and get into the heart of what we're here to talk about today. Let's talk a little bit about the agency I work for with the U.S. Department of Labor. That's the Employee Benefit Security Administration. And our mission statement is basically ERISA, the federal law we have jurisdiction over, which stands for Employee Retirement Income Security Act, or ERISA, is the law that EBSA has jurisdiction over. So plans that fall underneath that, employee benefit plans that fall underneath that, are what we work with. And so the goal, the mission is to assure the security of those kinds of employee benefits that we have jurisdiction over: retirement, health, COBRA, et cetera, by having effective regulations, assisting and educating workers, plan sponsors, fiduciaries, and service providers, which is something that a benefits advisor such as myself does, as well as vigorously enforcing the law. And that's what our enforcement or investigative unit does. I provide this organizational chart, not that I plan to go over it in detail by any stretch, but just so that you're aware of the different components of our office. We have 10 regional offices. Kansas City is one of them, and we cover 11 states. You'll notice the states that we cover that include Missouri. They're towards the left center. We have the most states, I believe, in our jurisdiction. Just a little bit with regards to what benefits advisors do. Obviously, we do outreach presentations such as the one you're experiencing today and might be attending in the future, hopefully with us, either with University Extension or perhaps another organization. But what we do, in addition to these outreach presentations, are the education and assistance piece, probably through our toll-free line or also available on our website. And the last slide has the web address of our web address, and also how to make a web inquiry if you'd rather do a web inquiry rather than call us on the phone, or if you have documentation that you might be helpful for us to look at or what have you. So we help not only participants, but employers, plan officials, service providers to employers and plan administrators. And then that's the vast majority of the calls and web inquiries that we take. But there are certain circumstances where we get involved with informal dispute resolution with regards to specific ERISA matters. Perhaps someone didn't get a COBRA notice timely, or they're being denied a health claim or a pension benefit claim that it appears that they that perhaps should be approved, and it's the kind of situation that we get involved in. Some we do, some we don't. I won't belabor which ones we actually get involved in at this point, but there are times that we do the informal dispute resolution piece. And then the other half of our agency basically is the enforcement unit, where they conduct civil and criminal investigations of potential violations of ERISA. And basically, I'm not going to go over our results too much. We helped recover a lot of benefits for people. There were many investigations closed, but notice that we had 1,600 voluntary fiduciary correction program applications were received, 1,600 of those. We'll talk a tad bit about the voluntary fiduciary correction programs today, but there's also a program on that on September 24th as well. And over 20,000 delinquent forms received of the required reporting that plans have to do with our agency. So I'm going to talk a little bit about ERISA, and basically note that there's 4 different titles to ERISA, but the EBSA, my agency, only has jurisdiction under Title I, the reporting and disclosure aspects, reporting to the government and disclosure requirements from the plan to the participants, as well as the fiduciary duties that are owed to plans. We have jurisdiction over Title I, as I said, of ERISA. The different aspects I won't go into in detail today. You can see them there on your slide. But COBRA and group health plan part 7 are definitely part of what I can talk about. Okay, so basically there's many laws that are under ERISA's umbrella. COBRA, the Consolidated Omnibus Budget Reconciliation Act, and I'll talk a little bit about that. I'll also talk a little bit about HIPAA, which stands for Health Insurance Portability and Accountability Act. A tiny bit about the Newborns and Mothers Health Protection Act. We frankly don't get a lot of calls with regards to that, and it's pretty straightforward. A little bit about the Mental Health Parity Act, which was amended by the Mental Health Parity and Addiction Equity Act. And like I said, there's going to be an entire presentation devoted wholly to that topic on August 26th. The Women's Health and Cancer Rights Act, the Affordable Care Act, which we'll talk about some today, the Pension Protection Act, and the 21st Century Cures Act. So what is an ERISA group health plan? Basically, major employment-based plan coverage, providing medical care, hospitalization, sickness, prescription drugs, vision, and dental. A major medical plan might include vision and or dental benefits, but very often, as we know, employers will offer a standalone vision plan, a standalone dental plan, and we also have jurisdiction over those plans. Plans can provide benefits through what's called a fully insured plan or insurance, or be self-insured. So fully insured would basically be where you pay premiums to like Blue Cross and Blue Shield or Cigna or something like that, and they cover or take responsibility for the cost of the claims that are insured. Or the plan can be self-insured, where the benefits claims that are paid actually come from the employer's assets. So the employer pays those claims, or from a separate trust set up to pay those claims. Now, one thing to not be confused about is that very often a plan or a carrier such as Blue Cross and Blue Shield or Cigna or Aetna or what have you might be a plan administrator for a self-insured plan, where they, as the plan administrator, adjudicate and determine the claims that get paid for the self-insured plan. So just because Blue Cross and Blue Shield or Aetna or Cigna or what have you are involved doesn't necessarily mean it's a fully insured plan. It might very well be a self-insured plan. And if you're working with the group health plan, it's important for you to be aware of whether or not your plan is self-insured or fully insured. Arrangements not subject to Part 7, which Part 7 of ERISA. Very small group health plans, under 2 people. Church plans, we don't have jurisdiction over church plans, or government plans, or accepted benefits, benefits that don't fall within what the nature of the benefits that we have jurisdiction over. I'll just mention a little bit about the Affordable Care Act market reforms. Basically, though they apply to plans that are non-grandfathered, which are essentially plans that have lost their grandfathered status. And so there are aspects that determine whether or not a plan is considered grandfathered. And if it's grandfathered, then there are many, many aspects of the Affordable Care Act they would not have to comply with. So if they're non-grandfathered, they have to comply with the provisions of the Affordable Care Act, depending on the kind of plan or nature of plan that it is. There's a prohibition of pre-existing condition exclusions, which was new under the Affordable Care Act, and certainly something that a lot of people are very happy about and grateful for. Not necessarily everybody, but certainly a lot of people. We already had wellness programs before the Affordable Care Act, but it modified the provisions of wellness programs. It imposed a limit of a 90-day waiting period for someone to be able to be eligible for the group health plan if they're otherwise eligible for the group health plan with an employer or a union. There's a prohibition on lifetime or annual dollar limit. There's a prohibition on rescissions. And what that basically means is the plan can't say, oh, we found some kind of a minor error or omission in the paperwork that you originally submitted, so we're just going to rescind you from the plan retroactively back to the date that you started the plan, which could be several years. There has to be some kind of a misrepresentation or fraudulent element in order for them to do a rescission in most circumstances. There are other circumstances where they might be able to do that. For instance, say a spouse a couple gets a divorce and someone is no longer a spouse, but they don't notify the plan that they're no longer a spouse. So they're technically no longer qualified as a dependent under the plan, but if they never notified the plan that they're no longer a spouse, the plan can rescind their coverage back to the date they lost eligibility. And so that would be an example of an acceptable rescission. But otherwise, other than those kinds of circumstances, there is a prohibition on rescissions generally under the Affordable Care Act. Coverage of preventive health services, there's a lot of circumstances where if it's considered a preventive health service, the plan is required to cover it without charge, copay, et cetera. Extension of dependent coverage up to age 26 for many plans in many circumstances. There's also a new requirement of a summary of benefits and coverage and a uniform glossary, and we'll talk about this a little bit more, as well as new rules regarding internal claims and appeals, as well as a new opportunity for something called an external review, which we'll go over briefly also. And then patient protections provisions, such as that if one goes to an emergency room, the emergency room visit needs to be paid at an in-network rate, for example. Okay, let's talk a little bit about wellness programs. Under the HIPAA non-discrimination requirements, which is one of the portions of HIPAA that our agency has jurisdiction over, we don't, for example, have jurisdiction over HIPAA privacy rules, but we have jurisdiction over HIPAA non-discrimination requirements, which basically means that a plan can't require an individual to pay higher premiums or contribution rates than other similarly situated individuals based on a health factor. So they can't say you have cancer, therefore we're going to charge you more. However, there are circumstances where someone might pay a higher premium or contribution rate. An example would be if they have wellness programs that fall under ERISA and meet the requirements for those wellness programs, it might result in a circumstance where people pay different premiums. Okay, the summary of benefits and coverage and uniform glossary. So this, as I mentioned, came about under the Affordable Care Act. And what the idea behind the summary of benefits of coverage is that it provides an apples-to-apples kind of comparison between group health plans if someone is trying to look at the different options available to them. Perhaps they're looking at an individual plan coverage that's not available through an employer or through a union. Or perhaps they're trying to consider a marketplace plan under the Affordable Care Act, under Obamacare, if you will. And they want to see if are they better off doing the marketplace plan or their employer's plan. Excuse me. Sometimes it's a circumstance of the person all of a sudden is eligible for COBRA, which we'll talk about a little bit in the future. Excuse me, I'm sorry, I have a little tickle. Hopefully that's gone away. And I apologize. Amy assures me that the glare is not distracting, but I see that there's a glare a little bit on the computer screen that I can't seem to get rid of, so I apologize for that also. But back to the summary of benefits and coverage. If someone all of a sudden might have having perhaps lost their job and their eligibility for their employer-sponsored plan as an active employee, and all of a sudden finding themselves with the option of choosing COBRA as continuation coverage of the coverage they just lost eligibility for. But COBRA very often comes with a huge price tag. So the person may be not only looking at the individual option or the marketplace option, but if they have a spouse with a group health plan that has eligibility for dependents, they might be comparing the COBRA versus the spouse's plan, excuse me, or their employer plan in general versus the spouse's plan, or just basically looking at the different options available. Or they may have another job where the other job offers in a group health plan also. That's rare, but it does happen occasionally. And so basically there are a list of requirements that must be in the summary of benefits and coverage. And it has some pretty strict limits with regards to a template of what that information must contain so that people can make an apples-to-apples comparison between plans so that they can determine which plan is in their best interest to join. One of the strict requirements is it's limited to 4 double-sided pages with no smaller than 12-point font. Excuse me, I'm so sorry. I'm trying to get rid of this tickle. Hopefully that'll do it. I'm so sorry. Okay, so the other thing that's awesome is that there is a uniform glossary where plans need to use the same terms to mean the same thing. And I'm going to let you know a couple of things that are helpful about this. If you've worked with group health plans for very long, you've already learned that there are times when a term is basically a term of art and doesn't necessarily mean what, in the insurance industry, what you intuitively think it might mean. And so a lot of participants get caught up in some of these issues where the intuitive definition is different from the term of art industry standard definition. An example is the idea of an out-of-pocket maximum. You may or may not know, hopefully you do know, but you may or may not know, the out-of-pocket maximum typically means the allowed amount under the plan that's approved by the plan after the participant pays so much, say it's a $5,000 out-of-pocket maximum, counting the allowed amounts that are allowed under the plan, not counting co-pays or co-insurance. And a copay, as you probably know, would typically be a set dollar amount, like a $30 copay to see a doctor in network perhaps, or a co-insurance is typically a percentage. You pay 30% of an item or something like that. Well, in the out-of-pocket maximum, it may or may not, but typically doesn't include the amount they pay for copays and co-insurance. But very often, intuitively, a participant will assume that an out-of-pocket maximum means once I have paid out of my pocket the $5,000, and they tend to count everything, not only allowed amounts, but perhaps amounts that the plan denied. So say there's a $2,000 claim that the plan denied, and so the participant says, well, I paid $2,000, I'm counting that towards the $5,000. Well, as you understand or just heard me say, it's only for amounts that are allowed under the plan that get counted towards that. Or sometimes they include the copays or co-insurance that they pay if that's not according to the plan rules as their out-of-pocket maximum. So it doesn't necessarily mean once I have paid this much money, or sometimes they even include their premiums in their understanding of that. But this glossary explains this is what a typical out-of-pocket maximum means. And if the plan differs from that at all, then the summary plan description, which we'll go over that in a minute, should include if the plan has definition changes with regards to certain terms. So that information should be made available to people, and they're held to a standard of having read it and understood it, which, as we all know, people may not even know there is such a thing as a summary plan description for their plan, telling them what's involved in their coverage and the limits, et cetera. And so they certainly may never have read it if that's the case. Okay, so let's talk a little bit about time limits for deciding group health plan claims. There were rules with regards to group health plan claims prior to the Affordable Care Act, but the Affordable Care Act amended this to some degree. For urgent care, meaning basically, significant medical issue or perhaps death, or something bad is going to happen to them on a health care basis if they don't get this care soon or right away, the initial claim must be determined within 72 hours, and the appeal must be determined within 72 hours. a pre-service claim, which we typically think of as prior authorization, the initial claim, the plan has 15 days to come up with a determination, but there are circumstances where they can get extensions for that and notify the participant of that. They can get one automatic extension, and then they need to let the participant know why they need an additional extension if they get an additional extension. And then for a prior authorization appeal, the plan has 30 days to come up with a decision or a determination with regards to that. Post-service, meaning they've already gone to the doctor or they've already had the surgery, they've already incurred the claim. The plan typically has 30 days for the initial claim to make a determination, and then if an appeal is filed on that, 60 days to provide a decision with regards to that. But under the Affordable Care Act, there's a new provision called an external review. So in the old days, and still what happens with regards to internal reviews, is that the carrier or the plan administrator review their own systems and circumstances and rules and plan provisions that they are applying in a situation and make a determination as to whether or not they're going to uphold their original decision to deny the claim, because you're only going to appeal a claim that's denied or partially denied, right? And so in the old days, the plan administrator and carrier was the really short of a court, the only opportunity for a claim to be reviewed and perhaps overturned. But under the Affordable Care Act, we have a new opportunity for external review. And this only applies in circumstances where a claim is denied based on medical judgment. So, for instance, if it is a claim that's denied because we just don't cover that kind of procedure that you received, like cosmetic surgery or something like that, that's not medical judgment. That's based on the plan rules. So that's not subject to external review. But if it is something involving medical judgment, they didn't think it was medically necessary or what have you, then that's something that can go for external review. And one of the things that I often find very helpful to share with people is that it's crucial for everybody to understand that medical necessity is not based on solely on what the doctor deems to be medically necessary, or certainly not what the patient deems to be medically necessary, but it's basically what's covered according to the plan rules. And so there are certain things that, very few things, frankly, that have to be covered by plans. That's really a whole nother presentation that we could actually set up. But if it's not legally required to be covered, then the plan gets to determine if they cover it and under what circumstances they cover it. And so just because a doctor says it's medically necessary, under the federal law, that doesn't mean it's something that the plan would cover. The plan gets to determine what they cover and under what circumstances. And one of the things that I just want to make clear to people that I try to educate people about, and it's helpful for you to understand, and also maybe in your conversations with participants, if this might be helpful and save everybody a whole lot of time, and maybe multiple appeals and lots of paperwork, if you could help them understand this or have them call me or my colleagues to explain it to them, is that there's certain things they can do to get their questions answered to find out the information that they need to know. But very often they don't know the right questions to ask. So, for instance, just because a plan says we cover something, that can be misleading, because it may be the case that they only cover something less than 1/2 of 1% of the time. So just because it's covered doesn't mean it's going to be covered in that person's circumstances or meet the criteria. So you always want to know what the criteria is, if it's covered, and then if it is covered, under what circumstances or what criteria is necessary in order for it to be covered or essentially approved for payment. And it is that I often give is that I talked to someone who they called and found out that their plan covered Wellbutrin. So they had Wellbutrin, which is a drug, a prescription, prescribed for them. But come to find out, Wellbutrin was only approved for depression, but not for smoking cessation, which was what they were prescribed for. So not only is it covered, but is it covered in my circumstances? What is the criteria necessary in order for it to be approved for coverage? Okay, so with regards to the external review, which is only available once you've exhausted the internal appeal process, or if the plan administrator or the carrier has basically messed up so badly in the internal review that it is a circumstance justifying immediately going to external review, which would probably warrant an individual conversation if you want to call me or call the toll-free line if that situation comes up in your line of work. Feel free to call me or one of my colleagues to discuss specifics there. But basically, there's federal processes for external review for that are available. So it goes to what's called an IRO, or an independent review organization, or there's a Health and Human Services administered process. Some states also have state processes available to them. Okay, so under the Mental Health Parity Act, we're going to shift gears a little bit to the Mental Health Parity Act. Originally, it was known as the Mental Health Parity Act, but in 2008, it was amended and became the Mental Health Parity and Addiction Equity Act of 2008, and it works in tandem with the 21st Century Cures Act to some degree. Now, mental health parity actually can be quite technical and complex, and we have very good resources and information on our website. You're welcome to call a benefits advisor, but honestly, I recommend the training that is going to be put on for you on August 26th by the Senior Technical Advisor for Health Plans in our office, Leandra Dodd-Arnold, on August 6th on Mental Health Parity and Addiction Equity Act. But I'm just going to briefly touch on the key provisions for a basic understanding of how the Mental Health Parity and Addiction Equity Act works. Basically, it's only applicable to plans that offer both medical and surgical benefits and mental health or substance use disorder benefits. Very few plans are required to offer mental health or substance use disorder benefits under federal law. So some plans aren't required. But if a plan does offer both, then they should adhere to the Mental Health Parity Act if it's a plan to which the Mental Health Parity Act applies. And there are plans that it does not apply to. We'll talk just a little bit about that. There's an anti-abuse provision where you have to look at all possible combinations of medical, surgical, and mental health substance use disorder benefits, and that's where it gets complex and technical. There are other aspects where it also gets complex and technical. But it does not apply to employers with 50 or fewer employees. However, under the Affordable Care Act, non-grandfathered small group market coverage must include coverage for mental health or substance use disorder benefits as an essential health benefit that the Affordable Care Act requires certain plans to maintain. However, one thing that's important to know, especially if you're a plan administrator or a plan sponsor, and certainly if you're a service provider, is that a plan, even if they're subject to the Mental Health Parity and Addiction Equity Act, if they meet certain standards, they can apply to receive an increased cost exemption, which basically, if they can meet the standards that are imposed, showing that it reaches the threshold of increased cost to the plan can apply for an exemption, meaning they would not have to adhere to the Mental Health Parity and Addiction Equity Act. And a lot of plans aren't aware of that. And so that might be something for you to be aware of and consider for your plan if that's an aspect that might be helpful for you to look at further. Okay, so a review of Part 7, and Part 7 being part of what our agency has jurisdiction over, includes disclosure requirements, which, as I hope you know, are the disclosure requirements that the plan has to provide information to the participants or the beneficiaries, which are basically the dependents of the participants that are either on the plan with them as a group health plan, or might be, in the case of a pension plan, a spouse or a minor child or something like that, or even just a beneficiary 401k. You're not necessarily related if you choose your beneficiary to be a non-related person. So there's a required disclosure for grandfathered plans. The plan has to say in their summary plan description whether that they're grandfathered and that they're non-grandfathered. If they're non-grandfathered, then there's disclosures that are required for internal claims and appeals, information about external review, and the opportunity of people's rights regarding designating a primary care provider. Other automatic disclosures, the summary annual report, the COBRA notice, when someone either first gets on a plan, the general notice within 90 days of them getting on the plan, or a COBRA election notice when they've had a qualifying event that allows them the opportunity of COBRA. HIPAA notices, there's quite a few of those. Notices and disclosures in connection with claims for benefits. Just a tad bit about COBRA. Basically, hopefully you know it's the opportunity to extend coverage of the plan that you're on, either through the employer or the union, as the employee, the spouse, or the dependent. If there is some kind of a qualifying event occurs that causes people to lose eligibility for the plan. To be entitled to COBRA, the group health plan has to be subject to the federal COBRA law. Basically, private employers with at least 20 full-time employees or the equivalent over half the year before. A qualifying event has to occur, such as the termination of the employee, meaning either voluntarily or involuntarily, or a reduction of hours of the employee such that it causes them to lose eligibility. Or it could be the death of the employee for the beneficiaries, or it could be a divorce or a child aging out of dependency status. And if they have to be a qualified beneficiary to be entitled to COBRA, which is, and meaning not only one of those people that I just described, but they have to be on the plan the day before with the employee, the day before the qualifying event occurs. Okay, I said this basically just now. Private employer sponsored group health plan, at least 20 full-time employees or the equivalent over half the year the prior year. Now let's just touch briefly on fiduciary duties for group health plans and retirement plans. The basics of retirement plans, which basically we haven't set one up, but we could set up a seminar on this topic also, with regards to different retirement plans that are available, particularly to small businesses, but just retirement plans in general. There's IRA-based plans. Benefit is accumulated contributions that the employee makes, typically, not always necessarily, plus the earnings that that plan makes. Defined contribution plans, such as a 401k or a profit-sharing plan, where there's the benefit consists of the accumulated contributions from the employee, typically, sometimes from the employer also, plus the earnings that it builds over time. And then defined benefit plans, which is basically when we typically think of a traditional pension plan, where you get usually a set amount of money monthly for life once you reach retirement age and qualify, apply for the benefit and it's approved. The elements of a plan, ERISA and the code, and by the code we mean the IRS code. So we share jurisdiction with the IRS. Employee benefit plans must be maintained pursuant to written instruments that describe the benefit structure and operation, who's eligible, the rules of the plan, if you will. And it requires that the written instruments provide for one or more named fiduciaries, people who are responsible for the operation and administration of the plan. But what is an ERISA fiduciary? Anyone who exercises discretionary authority or control over plan assets or administration of the plan, or gives investment advice for a fee. And basically, the key aspect here is a person just performing clerical or basic administrative functions for the plan, or do they actually have authority or control over plan assets or administration? And it's important to know that ERISA has a functional definition. It's not dependent on job title or documents. If it meets the bullet point above, then they would be considered an ERISA fiduciary. Basic fiduciary duties: to act solely in the interest of the participants and beneficiaries, to be prudent, which is a process that you should always document how you're being prudent, to pay only reasonable and necessary expenses of the plan, to know and follow the terms of the plan, and to hold plan assets in trust or with a licensed insurance company. It's crucial that you know who is responsible for various activities required by the plan, whether you do it in-house or whether you do it a little bit in-house and outsource the rest of it to a third-party administrator. People, even if you only do it a little bit in-house, and every employer does it at least, or union does it at least a little bit in-house, and it's important that you know that because some plan sponsors don't realize that. It's important that at least somebody know who all is responsible for all the various activities required by the plan. Who has custody of the plan assets? Who's responsible for record keeping and what part of the record keeping? Who makes the benefit decisions and directing investments? Tips to avoid common problems, and I always point this out as I think perhaps the most important slide in most presentations. Carefully selecting and monitoring service providers. Say you do hire a third-party administrator. You need to know what they're doing for you, and you need to make sure they're doing what you're supposed to be doing and be familiar with what's in your contract with them about what they're supposed to be doing. Make the required disclosures to participants and beneficiaries, whether you're doing it or the third-party administrator is, know what those are, and make sure they're being done. Understand your plan and your responsibilities under it. Make timely contributions and monitor plan assets and file reports with the government and keep good records. The one thing about timely contributions, this is something that I'm going to flag as something that's very important to understand what that means and that our agency takes very seriously. But we'll talk about that a little bit more here in a minute. Delegations. When assigning responsibility, whether it's to an internal committee or a human resources department or individual person within human resources or some kind of external service provider that's outsourced, make sure everybody understands their responsibilities. Make sure at least one person at the employer knows what everyone else is responsible for, preferably more than one person in case something happens to that one person. Make sure they have the knowledge and information necessary to carry out their responsibility. This comes up more than you would think. And you can call us. I mean, we don't train people, but sometimes we have helpful information to lead someone in the right direction. Sometimes someone will call us and say, hey, I got put in charge of COBRA today. What's COBRA? And so we know they're starting at the beginning and direct them to some helpful resources that we have available, like model notices for the general notice and the election notice and the publications we have available. Monitor to make sure they carry out their assignments. Record keepers. If you hire a third party to maintain the records, it's very important to make clear in your contract which records belong to the plan and when and how records must be maintained and made available. As the plan sponsor or the plan administrator, it is important that you always make sure that you also at least own the records, because if you fire them or they go out of business or for whatever reason they're no longer someone that you hire, you want to make sure that you have reserved and retained rights to the records that they have, because once you're no longer paying them, their incentive with regards to those records to maintain them and do a good job with them decreases markedly. So you want to make sure that you maintain the rights to those records. And the duty to maintain records cannot be avoided by contract, delegation, or otherwise. Even if you hire someone else to do it, if they mess it up, you're still on the hook as the plan sponsor and monitor their work. Briefly, what is a summary plan description? The basic ERISA disclosure document where it talks about the benefits, rights, obligations under the plan of both the plan sponsor, plan administrator, participant, and basically tells them what the rules are of the plan, eligibility, what's covered, what's not covered, what's required of them and of the plan, et cetera, to a certain degree. Not 100%, but at least the basics. And it must be written to be understood by the average plan participant. Other disclosures that are required for participants and beneficiaries. The summary plan description. If there are material changes to the plan, the summary of material changes. The summary annual report, pension benefit statements, plan documents. Pension benefit statements if it's a participant-directed defined contribution plan like a 401k or a profit sharing plan. Well, a profit sharing plan wouldn't be probably participant-directed, but like a 401k. If they get to choose and make their own designations as to where the funds are invested, then they get benefit statements at least quarterly. Otherwise, they're required to have statements at least annually. And if they're the typical defined benefit plan, that traditional plan that I described a few minutes ago, every 3 years they get a pension benefit statement. A blackout period, if it's a 401k plan, but there's going to be 3 consecutive business days or more, known as a blackout period, where the plan restricts a participant's ability to change investments or get loans or distributions, then the plan is obligated to provide a notice of the blackout period. There are specific content and timing requirements, and usually there has to be a minimum of a 30-day advance notice to all affected participants and beneficiaries. Okay, the annual funding, the annual funding notice. The traditional pension plans have to send these out. There are content and timing requirements here. There's also fee and investment disclosures that are important to provide. What information must be disclosed? General plan information, administrative expense information, and individual expense information for that particular participant. But there's also disclosures that must be made on request. And when we say request, we mean written request. You certainly can provide the information based on an oral request, but you don't have to. So if you get a written request or choose to honor an oral request, you must provide the plan document, the current summary plan description, insurance contracts, any other instruments under which the plan is established or operated, the plan trust agreement, or the document required to be filed with the Department of Labor in some circumstances, or and the IRS in some circumstances, the Form 5500 or the short form, and then other miscellaneous disclosures. How to furnish documents. In-hand delivery at the workplace, not the best idea. If you do it that way, then you need to document, perhaps have them sign something indicating acknowledgement of receipt, and document exactly who did what, when, where, et cetera, and maintain that documentation. You can do it by mail at the last known address they made available to you. Electronic delivery. And the one thing I'll say about this is, don't just assume that you can send things out by email and you're good. There are very specific, certain regulatory standards and that must be applied and must be met in order to do something by electronic delivery. And you can post in common areas, but it's not enough to do that. One thing that's just crucial for me to talk about just for a minute is contributions is something that we take very seriously and is very important. Participant contributions become plan assets as soon as they reasonably can be segregated from the employer's general assets. So basically, if it's an insurance premium, then those premiums must be paid never 90 days, but as soon as reasonably segregable from the employer's general assets. And that's as soon as possible. So 90 days would be highly unusual to be the reasonable amount of time. And contributions must be made in accordance with the plan document. The crucial rule that I just said, but I'll go over a little bit more. They must be transmitted as soon as they reasonably can be segregated from the company's general assets. For small plans, we have a safe harbor that it's deemed in compliance or as soon as can be segregated from the company's general assets if the participant contributions are received by the plan within 7 business days. And we typically expect that large plans, which has 100 or more participants, would be able to do it faster. So even if you could do it faster than 7 days if you're a small plan, we give you 7 business days as a safe harbor. Larger plans, we typically assume should be able to do it a little bit faster, like I said. We do have some correction programs available. We have the Voluntary Fiduciary Correction Program. We have a whole program available that you can listen to or attend on September 24th. And this is basically, there are many situations where a fiduciary can correct a mistake that they've made. And you have to find out if your situation is one of the situations that this program applies to, fill out an application process, provide documentation, etc. We also have a delinquent filer program if you haven't filed your Form 5500 timely that you can apply for. There are some publications that we offer on our website that I want to make you aware of. In addition to that other document that I provided to you of the seminar resource list of publications available. One is Getting It Right, Know Your Fiduciary Responsibilities is a publication on our website. Other publications on our website, Selecting an Auditor for Your Employee Benefit Plan, Understanding Retirement Plan Fees and Expenses, and very important, Meeting Your Fiduciary Responsibilities. So this is basically a list of other guides that are available on our website that you can look at to see if you want to look at those publications. The ways to contact us, if you want to file a web inquiry with a benefits advisor, that top bullet point is where you go to do that. If you want to call a benefits advisor, that phone number is who you call. A couple of offices within our agency that you might find helpful, as well as our website. You can also subscribe to our website if you want to receive updates on that. So basically, thank you very much for your time and attention, and I appreciate the opportunity to get to talk to you. You should have a copy of the slideshow as well as that resource list that I mentioned that has information about fiduciary education opportunities, publications, fact sheets, FAQs, etc. So at this point, the last thing that I'll say is don't forget that we'd be happy to set up a presentation on a panoply of topics or one topic in general or what have you. So if you're a member of a nonprofit that would like to have me or a colleague out, please do contact me. I gave you my contact information before, Kathy Robinson, as you know. And it's been a pleasure to talk to you, and I'd be happy to answer any questions that you have. Amy or Matt, are there any questions in the chat box?
Thank you, Kathy, for your great presentation. At this time, there are not questions in the chat box, but we encourage people to open their mics and ask questions to you directly, or they can post the questions in the chat box. We appreciate your time and expertise today, Kathy. You've shared a wealth of knowledge with us. Please be sure to sign up for the upcoming webinars. The links and information that Kathy referred to have been added to the MU Extension Labor and Workforce Facebook page and the LinkedIn page, which I provided the links to in chat. And finally, we ask that if you're willing to share the webinars on your social media and within your professional organizations, we ask you to do so that we can get the reach for Kathy and the Department of Labor that we want for participation in the webinars. And thank you all for your participation today and for your time to join Kathy. We hope that you join us next time on August 12th. If you have questions for Kathy, please unmute your mic or post them in chat at this time.
And it's been my pleasure. Thank you, Amy.
Thank you. I'm just watching the chat, Kathy.